Hello, everyone. Good morning. As I mentioned last night on the forum that we're going to have a guest speaker today, and you can see he's here. His name is John Klopfenstein, and he used to be a defense attorney, and he's currently a practicing attorney in the state of California here in the United States. And he will be talking to you about introduction to defenses in criminal law. Okay? So I'm going to hand over the lecture over to him, and I will see you guys afterwards.
First of all, my name is John Klopfenstein. I'm an attorney here in the state of California. I've been an attorney for over 20 years in criminal defense, and I have been a public defender 10 years in Sacramento and 5 years in Monterey, and I have my own private practice. We're going to be discussing defenses, and I would like to refer you to your materials if you have them with you, and this would be on the defenses at page 108. And as you can see, there are two types of defenses that they're talking about. They're talking about defenses that would be basically affirmative defenses. These are the type of defenses that would be used to potentially negate the mens rea. I think you probably learned earlier in your criminal defense lectures that there is an actus reus and a mens reus that need to be proven in order to prove up a crime. And so basically what they're talking about here is they're talking about the affirmative defenses, which would be excuse or justification. Now, excuse is referred to as, I think they make reference to involuntary conduct, and that is 10.2 on your materials. Involuntary conduct refers to negating the mens rea. And what that means is that they're talking about here someone that may have some sort of, let's say, is a sleepwalker. I believe they use this in this particular example on 10.2. And someone that's a sleepwalker that is asleep and gets up and picks up a hammer and hits somebody over the head, causes death, they have an excuse. They have an excuse because of the fact that they were involuntarily unable to form the mens rea that is necessary to commit the crime. Now, understand that there's references to involuntary intoxication. Involuntary intoxication, for example, would be going to a party, and at that party, someone puts in LSD in the punch. And in putting LSD in the punch, you drink the punch, and all of a sudden you hallucinate. You think that someone is a snake. You pick up a gun and you shoot at it, and you kill that person. You have a complete defense, and that is called involuntary intoxication. Another excuse type of defense, which is discussed, I think, later in the materials, is justification. Justification is used by the police. When someone, a robber, is leaving the bank and the police arrive, they pull their guns, they say stop, and they continue, and they're shot and killed. That's justification, and the police officer is completely absolved of any sort of criminal intent based on the fact that the mens rea has been negated. Now, we go into 10.2.1. They talk about physical involuntary, and they get into some sort of, let's call it mental illness, some kinds of illnesses which would potentially negate the mens rea used. Now, in California, interestingly enough, there is no longer diminished capacity. Diminished capacity was abolished in 1981, meaning that if you voluntarily become intoxicated and you try to use that as a defense to murder, it would no longer work. You would be convicted. So if you went and you voluntarily became intoxicated, you would be convicted because of the fact that here in California there is no such thing as diminished capacity, meaning that even though you are in a diminished state of mind being intoxicated, you can still commit the crime. However, in this particular lecture, that's the case that I talked about the fact that we have a guy and that person has not said food and I don't know there in England, and this decision said that that particular state of mind could be considered as an involuntary situation, and therefore the mens rea would be then we'll get into we get into what they talk about strict liability offenses. And in this particular situation, they're talking about bad driving, serious driving. They're talking about auto, meaning having a disease that you can't control your actions. That is a defense. However, you need to contrast that with insanity. Insanity and this automatism are very similar. Insanity, and let's get into that. Not test is a test, a right-wrong test. The McNaughton test is a test that is used to determine if the individual who's claiming insanity knows right from wrong. It is actually a very high, and it's used in the United States. It's the majority rule in California. It's the test in California. In California, Section 1026, and it is used in situations where individuals think that that there's a Martian, and the person that's attacking them is a Martian, and they have to defend themselves, and they have to then kill that person. It is a two-pronged test, and I don't know if it gets into it in the various materials, but understand that in a 1026 type trial, first of all, it's a bifurcated. You litigate the actual murder itself, and then you get into the insanity phase. And in the insanity phase, it's a battle of the experts, where one expert comes in and testifies that at the time of the perpetration of the offense, the defendant was insane, didn't know right from wrong, and of course the prosecution is going to be presenting an expert that will say just the opposite. It will then go to a jury, and then a jury would decide whether or not that individual was insane at the time, and that is not considered to be an acquittal per se. What it is a situation where they would put the defendant in a mental institution, and potentially could be in that mental institution for life. So I believe in the materials there's some mention of the fact that would be considered to be an acquittal, but I disagree with the materials in that I would say that it is not an acquittal, but it is, I guess, considered to be a better situation than being sent away to a prison for the rest of your life, as opposed to being in a mental institution. It probably is a little gentler and kinder situation. The disease of the mind, people that are saved clearly have a disease of the mind. Representing an individual who was he was in prison. He was in a cell with another man, and this particular individual thought that his cellmate was a Martian, and he ended up killing that cellmate. And we went on for 5 years to determine if, in fact, this particular individual at the time was insane. We finally got it to a jury, and we had a battle with the experts, and he was found. Or which is intoxication. As I talked about earlier, we have two types of intoxications. We have involuntary intoxication, and we have voluntary intoxication. Now, involuntary intoxication is the example I used regarding the LSD in the punch bowl. You go to a party, somebody pours LSD in there, and you start to hallucinate, and you end up killing somebody. That's involuntary intoxication, and that is a complete defense to murder. Voluntary intoxication is not a defense to murder. However, it does mitigate, under circumstances, can mitigate murder down to manslaughter. And that could be significant because in California has first-degree murder, which is 25 years to life, and second-degree murder, which is 15 years to life, where manslaughter is considered to be a determinative term, meaning that it's a 10-year term, and once you serve those 10 years, then you get out. Obviously, you would be on some kind of parole, but you would get out of jail and you would be incarcerated for the rest of your life. So if, in fact, an individual was drinking, got so drunk that they mistook what was transpiring and fired a gun at somebody, it's a little bit like a mistake in that they're so intoxicated that they can't form the mens rea, the malice that's needed in murder, and so therefore it's mitigated down to for one, they talk about restrictions on the use of intoxication, and this is the restrictions that have to do with the general intent crimes versus specific intent crimes. Oh, they can't hear me? Oh, okay. All right. Can you hear me, everybody? Okay, I hope so. All right. So, anyway, this is general intent crimes versus specific intent crimes. And general intent crimes, intoxication does not apply at all. It is not a defense to any general intent crimes. It is only a defense to specific intent crimes, and generally specific intent crimes would be theft crimes and crimes, murder has a malice in it, which is a specific intent crime. Arson, really the serious crime. And so if you were to become intoxicated and again, you murder somebody, that can mitigate it down to manslaughter. Now they talk about on 10.4.2, which is called Dutch courage, which is an interesting concept. It's not a concept that I've seen in the United States. It appears to be specific to England, but it does have an interesting effect, is that if you're going to go and you're going to kill somebody and you need to get courage, meaning you go into a bar and you're going to get drunk, and you get drunk, and then you go ahead and then murder that person, that is not voluntary intoxication. That is considered to be, in England, it's called Dutch courage, and it is held that it is not a defense, and it can't be used in murder, and it can't be used to mitigate any of the specific offenses. The crimes of basic intent versus specific intent, and the contrast between those, in that intoxication does not apply to any general intent crime. As I said before in 10.5.1, that intoxication is a little bit like mistake, in that what happens is that the individual becomes so intoxicated that they end up making a mistake, meaning that they think that something is transpiring that isn't transpiring, and then they use force that's a deadly force, causing murder. And what it can do is it could mitigate the murder that we can have. And it's a little bit like we can get into self-defense. Self-defense is a complete defense to any crime. However, if you've probably learned that, am I doing okay? Okay. So I apologize if, yeah. Okay. So, as I was saying, intoxication is a lot like a mistake, in that what happens is that the individual becomes so intoxicated that they believe that something is transpiring that isn't transpiring, and they then use force, deadly force, and that force can be mitigated down to manslaughter. So when they're talking about in 10.5.1, intoxicated mistakes as defense, that's really what they're talking about. Even though it's not considered to be a mistake, it's considered to be a situation where the individual can't form the mens rea necessary, such as malice in murder, and therefore then it's mitigated down to manslaughter. Now understand that these defenses are used in a way to either have a complete acquittal or are used to mitigate crimes from the more seriousness of them down to less serious type crimes. So they can be used, like for example in self-defense, if somebody is attacking you and you defend yourself and you don't use excessive force, then if you end up killing that person, then you have a complete defense to murder or any other crime. However, there is an exception that if you use excessive force, meaning that if somebody attacks you with their fists and you pull out a gun and you shoot them, that's an excessive force. That's considered to be an imperfect self-defense. An imperfect self-defense mitigates murder down to manslaughter. So even though the defendant may have used excessive force, it may have looked like it was a murder, if there is some evidence that he or she was defending themselves, then that would mean that it would be mitigated down to manslaughter. So like I said, these defenses, when you're thinking about them and you're taking your tests, they're used in two ways. One is they're used as a complete defense. Two, they're used in a way to reduce the crime from the serious crime down to a lesser crime. So if you get a test and you have an issue, a criminal law test, and you see that the person is charged with murder, then you want to start thinking about defenses to the murder. You want to start looking into self-defense. You want to start looking into potentially defense of others. You want to start looking into possibly necessity. You want to look into if there's issues of alcohol. Then you want to your mind is going to start thinking about the fact that this is going to be an intoxication defense. Is it involuntary? Was it given to him where he didn't know or she didn't know that what they were doing, or is it something that was voluntary? So those are the issues that you want to consider on your tests when you're taking your bar exams in the various countries that you're in. So I think that takes us on to the affirmative defenses, which is Chapter 11, and I think I've discussed some of those already, which is self-defense. Now here in 11.1, in 11.2, they talk about public and private defenses, self-defense. Well, a public self-defense is really justification. I don't know why they don't discuss that, but it is a public, meaning a police officer in the line of his duty, defending the public from a serious crime that may be going on, and uses force and kills somebody. That's considered to be justification, which is a public self-defense. Now going into 11.3, which is an important issue, which is the reasonableness of the force. Obviously, the reasonableness of the force is an objective standard, and it's going to be a standard that would be the reasonable man standard. However, I think it's pretty obvious that if someone would attack you with their fists and you use the knife or you use the gun, that would be considered to be excessive force, and it would be unreasonable force. It wouldn't be reasonable. Reasonable force is force necessary. I believe it would be defined the force necessary to defend yourself, given the circumstances. So when they mention here in the materials about grossly disproportionate, and I believe that would be probably a pretty good standard, that if it's grossly disproportionate, it is unreasonable force. So on your tests, if there's a self-defense, there's a situation where somebody's tapped on the shoulder and somebody turns around and uses a gun, that's pretty obvious. That wouldn't be considered a self-defense. But then the next question is, does it mitigate it down from murder? Does that mitigate it down to manslaughter? So if there's an issue about what crime was committed, there's a situation that may not be murder. It could be something less. Because of the imperfect, there's apparently no duty. In California, there's also this situation, no duty to retreat. So there isn't a duty that you have to retreat from the situation before you can claim the defense. And it says that the use of force must be necessary, and again, that's considered on an objective standard, whether or not the force is necessary, whether or not someone really is in a situation of being attacked. And again, provoking the attack, if you are the provoker, then you cannot claim the defense. You have to be the person that is being provoked. So in 11.3.3, if you are provoking an attack, you then cannot, unless what happens is that the force that's used, it can be one of these back and forth situations where you're in a fist fight with somebody and you provoke it, it's over, and then the individual picks up a gun and shoots you, and you have to defend yourself, and then defending yourself, you shoot him first, then you have a self-defense. So be careful when you're looking at these types of situations, particularly on tests. They like to test in areas where you're the provoker, and then what happens is that it comes to some situation where there isn't any further fighting, and then the person who was provoked ends up being the provoker, and so you can then get the privilege back, get the defense back. In 11.3.5, they talk about reasonable force, which is an objective standard. And again, they talk about the grossly disproportionate between using reasonable force and using unreasonable force. However, I believe they get into imperfect self-defense, which again mitigates the situation down to manslaughter. And that gets into duress. Duress is a interesting defense. And one thing that I want to make clear to everyone here is that these defenses are used in a jury trial, and in order to get the defense, you have to ask the judge. And in California, it's a preponderance of the evidence, meaning just 51%. So it's not too difficult to get a judge to rule in your favor regarding a defense. However, I was in a situation very early into my career where I was in Los Angeles, California, and a guy I was defending, he was had a drug addiction. His drug dealer, who he owed a lot of money to, got into the business of trafficking white women from California, transporting them over to Japan and putting them into prostitution. And what he did is that he got involved in a scheme where he tried to kidnap a white woman. He got a taser, he had a van, and he zapped her with the taser. However, she was able to get out of the van and run away and call the police, and he was then put on trial for kidnapping. I used the defense of duress, meaning that because of the fact that his drug dealer was claimed that he was going to hurt his family and a lot of things, that he then went ahead and he did this crime. However, the most important part of this duress is that it has to be an immediate situation, meaning that it can't be conditional. It can't be based on, if you do this, then I'm going to hurt your family. There has to be a situation where the person really is in a state of where they've got a gun to the family's wife's head, they got the children, and then they say, now go out and do this crime. I believe that in your materials, there's an example of a guy who wants to get to the airport. He puts a gun to the head of the taxi cab driver, and then the taxi cab driver breaks all the laws, and you know, that's considered to be duress. And they make a differentiation between, I believe it's physical threats versus duress. Okay, so duress by threats is generally the kind of duress that you're going to see probably on your tests and you would see in real life. It would be a situation where the family, generally it's a family, they're kidnapped, and then what they do is they force the person to commit a crime that they normally wouldn't commit, but because of the threat. Now, understand duress is not a defense to murder. So even though you are faced with a situation where your family is being threatened, it's an immediate threat, and they say go out and kill somebody, you can't use that as a defense to murder. And it doesn't mitigate the situation down to manslaughter. So it isn't a defense really at all in that circumstance. It's only a defense to all the other crimes, and the examples that are used in the material seem to have to do with driving somehow or another. Somebody is put a gun to their head and they drive around and they break the law and they and all that. And so those are the type of defenses that are used in that particular situation. And I think this is 11.5.2. You turn to page 131, you'll see there that it says that a threat must be directed against the defendant his or her immediate family or someone close to the defendant. Now, understand that means that threat has got to be it's got to be carried out. It's got to be able to be carried out. It can't be conditioned. And so I think you may see on your test there's a subtlety there. So look for that in your exams, that the subtlety between a conditional threat and an immediate threat that could be carried out, because that's where the bar exams, they like to test in that area, and they like to see that you know that difference. We come to 11.16, which is the rest of circumstances, which I was reading, and this type of duress really doesn't exist in California. And again, it has to do with allowing someone who is reckless driving and felt that he was that these people were apparently gang members and had to get away, and by getting away ended up hurting somebody, and because you're threatening to shoot somebody. And apparently in England that's allowed. I've never seen it in the United States. So but understand that apparently in England, and maybe on your bar exams, there may be some differentiation between duress of threats and duress of circumstances. It can be a necessity of self, or it can be necessity of others. Generally, what you do is you see it in necessity of others, in that what happens is that there's a difference between your brakes go out in your car, and there's a huge crowd of people, and that if you don't stop the car, you're gonna kill a number of people versus killing one person. That's considered to be necessity, and it is a defense, obviously, to murder. Another one would be acts of nature, where you're in a hurricane, there's floods, and the individuals are maybe going to be drowned or killed, and so it's by saving the greater, and someone else gets killed, then that could be viewed as a necessity. So generally, in a fact pattern, you're going to see a situation where the brakes go out, there's a parade, there's a number of people that are in the area, and the person has to make a decision between running over a number of people or running over and maybe going into somebody's store or whatever, hurting or killing somebody, and that's considered to be necessity. So I think, and they talk about necessity as a justification, and really justification is given to, well, that would be a justification because of the fact that you're saving the greater versus the lesser. But justification is used generally with police officers, giving them the right when they're on duty, working and saving the public, and there's a serious crime going on, and then they use and shoot somebody, and that's considered to be justification. And I think that goes through the entire overview of defenses. So I don't know if anybody has any questions now, but I'd take questions.
I have a question. My name is Rosemary.
Okay.
I was just wondering, when you have the client with the drug addiction, did he come to you with his defense, or did you interview him and ask him specific questions where this came out that he had the duress?
Oh, the drug addiction. I'm sorry, I didn't quite. Did I have an example of that?
Yeah, you had an example where there was a guy who was addicted to drugs, and he kidnapped a white woman with a taser in a van.
Oh, right. Right. Yeah.
So I was just wondering if in that situation, if it tends to be the setup that the client comes to you already with the defense, or if what happens is you have to be really inquisitive with the client of getting a whole bunch of background from them as to how they landed themselves in the situation, and that's how you discovered that he had a defense.
You know, it's a good question. It actually came out in interviewing my client, and he told me that this is the situation. What ended up happening in that particular case was that, as I said, was you have to have a preponderance, and the judge, you have to ask the judge if you're, you know, to get that particular defense. I thought that we had shown at least by a preponderance, but the problem was that it was a conditional threat. It was a threat that was not an immediate type of situation, and the judge differentiated between the two, and he didn't give me the defense, and therefore, when I went to argue the duress to the jury, I couldn't argue it because he wouldn't give me the jury instruction. Does that answer your question?
Well, like that kind of taught me something else, but I was just wondering where, like, how much sort of interviewing is involved in establishing whether you have a defense or not, and what kind of questions would you ask to get the information out of a client that they might have a defense without making suggestions to them so that they could create their own that probably wouldn't be fair, kind of thing. Like, well, I guess what I'm saying is,
you know, generally they blurt it right out. I mean, they pretty much tell you, you know, because you go in and you have a police report that is given to you by the prosecution, and you've gone through that report. And so, in interviewing, my first interview generally with the client would be, well, I've gone through the police report, and this is what the police say, and you know, what do you say? And then generally they say, well, that's not at all how it happened. It's all, you know, false, and this is how it happened. And so that's how you begin to develop a case and how you develop potential defenses. Does that answer your question?
Yes, thank you.
Okay, and then again, it's important, particularly with duress, again, that it's got to be an immediate. It can't be conditional, and I fell into the trap, and my client ended up getting convicted as a result because of the fact that it was a conditional threat saying that if you don't do this kind of thing, then I'm going to hurt your family, and that's, I couldn't get that defense. So do you understand that subtlety?
Yeah, and it's amazing what the difference can make with the subtlety, too. It's like the difference between whether he gets convicted or not. So that's great. That was a great story.
Yeah, and you know, again, it happens quite a bit, too, where you might go to a party and somebody may, you know, spike the punch and put in some, you know, LSD or something, and then that person then, you know, reacts in a way that ends up killing somebody. And you know, you used to see that in the 70s and the 80s quite a bit, where they were spiking the punch with LSD, and so that's a good example of involuntary intoxication. which is a complete defense versus voluntary intoxication. And a lot of times they like to test in those areas so that you can see the differences. They want you to see the differences between what would be voluntary intoxication versus involuntary. Any other questions?
Hi, John. Can you hear me?
Hi. Yeah. Who's this?
This is Andre.
Hi, Andre. How are you? I'm John.
I'm well.
Okay.
On the insanity defense, obviously there seems to be a reasonableness test as to whether someone is insane or not, and there, as you mentioned, a battle of the experts.
Right.
How popular is that defense, and is it very easy to win, or it's like once you start going on the path of the insanity defense, you're probably going to lose?
Well, I don't know about that. I don't know if necessarily you're going to lose. I might disagree with that, but understand that, and I don't think it's brought up in your materials, is that it's a two-pronged trial. And generally speaking, sometimes you can just stipulate to the actual murder. So generally there is you impanel a jury. A jury then listens to whether or not the defendant killed this person, the victim, and then if they determine that that happened and they go and deliberate, come back and say guilty, then it goes into the second phase, which is the penalty, or which is the insanity phase. In that particular phase, then what happens is then they bring in the battle of the experts, and again in California, and pretty much it's a right-wrong test. I think the materials, they do talk about an impulse, and there is an impulse, meaning that you can't control your impulses, and so that's not used in California. I think it is used in some states, and it is used around the world. But generally, I think the McNaughton test is the general test, which would be the right-wrong test. And so they've got to determine if this person really knew right from wrong, and that is where the expert is used, and it's really very important. Does that answer your question, or?
It does.
Andre?
Is there a possibility to have? Yes, it does. Is there a possibility to have a fusion of the insanity defense and that intoxication defense? Because if we're asking the question of being understood whether something is right or is wrong, then obviously by intoxication, that's one part of the defense. But if they have some kind of a mental defect, then you could go that route as well. So is it a matter of just kind of picking one and picking a horse and sticking with it?
No, you bring up an interesting point. I don't think anybody has tried to use alcoholism as a mental. It is considered to be a disease, and I don't know if anybody has tried that. It might be something that when you become an attorney and you're trying cases, that might be an interesting angle to use in insanity. But I haven't seen it used. But intoxication, voluntarily intoxicating yourself versus having a mental defect are completely different situations. And again, understand that you can't just when you're intoxicated. A lot of times, you get intoxicated and you remember everything that happened and you can drive home or whatever, but you were intoxicated. This is a situation where you're so intoxicated that you can't form the mens rea, meaning you can't form the specific intent to commit the crime, versus having a mental defect and thinking that you're being attacked by Martians, or you're being, some sort of, they're really completely different. So you wouldn't want to infuse, I don't think you can infuse it. The only way that you could infuse it would be to probably argue that alcoholism is some sort of disease, and that this person can't stop drinking and has ruined his brain through drug and alcohol abuse, and therefore now has caused himself to become insane.
Thank you.
Yeah. Any other questions? Okay. Well, I guess if there isn't any more questions, I want to wish everybody a good day and good luck. Thank you.